All persons having any business before this honourable court now draw nigh. Give your attendance and you shall be heard. God save the Queen.
Admission of lawyers. Miriam Asa.
Let Miriam Asa be admitted as a lawyer of this court.
Sean Patrick Bennell.
May it please the court, I move that Sean Patrick Bennell be admitted as a lawyer of this court.
Let Sean Patrick Bennell be admitted as a lawyer of this court.
Tom Francis Carroll.
May it please the court, I move that Tom Francis Carroll be admitted as a lawyer of this honourable court.
Let Tom Francis Carroll be admitted as a lawyer of this court.
Dmitry Fedorov.
May it please the court, I move that Dmitry Fedorov be admitted as a lawyer of this honourable court.
Let Dmitry Fedorov be admitted as a lawyer of this court.
Daniel Benjamin John Haig.
May it please the court, I move that Daniel Benjamin John Haig be admitted as a lawyer of this honourable court.
Let Daniel Benjamin John Haig be admitted as a lawyer of this court.
Tamar Page Hesteler.
Please the court, I move that Tamar Page Hesteler be admitted as a lawyer of this honourable court.
Let Tamar Page Hestelow be admitted as a lawyer of this court.
Min Kim.
May it please the court, I move that Min Kim be admitted as a lawyer of this honourable court.
Let Min Kim be admitted as a lawyer of this court.
Natasha Krikorian.
May it please the court, I move that Natasha Krikorian be admitted as a lawyer of this honourable court.
Let Natasha Krikorian be admitted as a lawyer of this court.
Alice Kwan.
May it please the court, I move that Alice Kwan be admitted as a lawyer of this honourable court.
Let Alice Kwan be admitted as a lawyer of this court.
Lakshmi Logathasan.
May it please the court, I move that Lakshmi Logathasan be admitted as a lawyer of this honourable court.
Let Lakshmi Logathasan be admitted as a lawyer of this court.
Lois Siobhan Mentakis.
May it please the court, I move that Lois Siobhan Mentakis be admitted as a lawyer of this honourable court.
Let Lois Siobhan Mentakis be admitted as a lawyer of this court.
Monica Victor Sobi Nakla.
May it please the court, I move that Monica Victor Sopki Nakla be admitted as a lawyer of this honourable court.
Let Monica Victor Sopki Nakla be admitted as a lawyer of this court.
Nishal Pakaro.
Let Nisha Pokriel be admitted as a lawyer of this court.
Thomas Alexander Strong.
May it please the court, I move that Thomas Alexander Strong be admitted as a lawyer of this honourable court.
Let Thomas Alexander Strong be admitted as a lawyer of this court.
Thasika Thuramalingan.
May it please the court, I move that Thasika Tharumalingam be admitted as a lawyer of this honourable court.
Let Thasika Tharamalingam be admitted as a lawyer of this court.
Wen Jing Wang.
May it please the court, I move that my wife, Wen Jing Wang, be admitted as a lawyer of this honourable court.
Let Wen Jing Wong be admitted as a lawyer of this court. It will be necessary for the purpose of an oath or affirmation that all those being admitted today stand up but remain in their current places. Could all the admittees please stand?
Miriam Asa. Sean Patrick Bennell. Tom Francis Carroll. Dmitry Fedorov. Daniel Benjamin John Haig. Tamar Page Hestelow. Min Kim. Natasha Krikorian. Alice Kwan. Lakshmi Logathasan. Lois Siobhan Mentakis. Monica Victor Sobi Nakla. Nishal Pakaro. Thomas Alexander Strong. Thasika Thuramalingam. Wen Jing Wong. Do you severally swear or declare and affirm that you will truly and honestly conduct yourselves in the practice of a lawyer of the Supreme Court of New South Wales, and that you will faithfully serve as such in the administration of the laws and usages of this state according to the best of your knowledge, skill and ability? Would you please say, "So help me God," or "I do"?
So help me God.
Would you please be seated?
Now that the formal part of the proceedings has ended, I would like to warmly welcome you to the Supreme Court of New South Wales. Present with me on the bench today is Justice Slattery to my right, who is a judge of the Equity Division of the Court, and Justice Lonergan to my left, who is a judge of the Common Law Division. Together we constitute the court that has, in exercise of its jurisdiction, admitted you to practice. As we gather here today, I would like to begin by acknowledging the traditional custodians of the land on which we meet, the Gadigal people of the Eora Nation, and pay my respects to their elders, past, present and emerging. We recognise the long-standing and enduring customs and traditions of Australia's First Nations and acknowledge with deep regret the role our legal system has played in perpetrating many injustices against Aboriginal and Torres Strait Islander people. To all the new lawyers here today, welcome to the legal profession. Today is a day for celebration. You've already worked extremely hard to get here, through caffeine-fuelled nights, trying to solve obscure problems, reading countless wafer-thin pages of textbook, and more cases than you can hope to remember. Don't worry, it's quite all right to forget most of them. You have entered a world of eggshell skulls, encountered a mysterious, reasonable person, and have understood that the Constitution consists of so much more than the vibe of the thing. In becoming a lawyer, you have today joined a centuries-old profession with ancient origins. The custom of advocates swearing an admission oath dates back to the 12th century. This court first admitted lawyers to practice in 1824, and by 1830 the names of lawyers were entered onto rolls in this state. You have now become part of this tradition almost 200 years later. Perhaps some of you, or your family and friends, feel that's how long you've been studying. On that note, I'm also pleased to welcome those with you today or watching on live stream. For many of you, of course, the support of your family and friends has been invaluable. No doubt they have also been on the receiving end of your finely polished skills of argument and persuasion. I hope you take the time today to thank them. The oath or affirmation you have made today is a serious one and it deserves solemn regard. Whether you work in private practice, at the bar, in a community legal centre, or in an entirely different field, you should be known for your honesty, your integrity, and your commitment to justice. It is in acknowledgement of this weighty responsibility that we observe today's unique formalities, including the moving of lawyers, swearing of oaths, and even our somewhat strange choice of fashion. On one occasion some years ago, I recall, a young member of the audience asked if we were doing Santa photos after the ceremony. Regrettably, I had to disappoint him. However, although we mark this occasion with formality and tradition, not everything in the legal profession remains unchanging. You will be unsurprised to hear that last year we had to adapt quite a bit. COVID-19 meant a rapid shift to increase use of virtual courtroom setups and technology to ensure that access to justice continued in the midst of a pandemic. Things didn't always go smoothly, as those with me on the bench can probably attest to. There have been real difficulties to grapple with in terms of open justice, effective communication and a fairness to participants. And occasionally a lawyer might even get stuck behind a Zoom kitten filter. But for all the challenges we face, the impetus is greater than ever before for us to prioritise flexibility and accessibility. Better use of technology and increased working from home arrangements have profound implications for how our legal system interacts with many people, including those in rural and remote areas, those with a disability, medical conditions, or carers' responsibilities. As the newest members of the profession, you are at the forefront of innovation in the law and have a unique opportunity to see through changes so that justice is done openly and equitably. There are, of course, other changes that deserve attention. When we think of the diversity of the legal profession, we encounter the duality that we have come very far and that much still needs to be done. Though women were originally not permitted to practice, since 2018, women have made up more than half of all the solicitors with a practicing certificate in New South Wales and currently make up 63% of solicitors under the age of 30. Women occupy many of the most senior positions in the law, including, of course, the Chief Justice of Australia. However, women continue to face challenges of representation, including amongst judges of this court and, for example, amongst barristers in speaking roles before the High Court of Australia. On the other hand, it is heartening to see that the local court of New South Wales has almost achieved gender parity amongst magistrates, but we must not be complacent about these issues. There are other noticeable diversity concerns that we must face head-on. Aboriginal and Torres Strait Islander people and people from diverse cultural backgrounds continue to be alarmingly unrepresented in the legal profession, and particularly within the judiciary and the ranks of senior counsel. We must also be alert to barriers to the profession from people from less privileged backgrounds. Law should not be a profession for the wealthy, and the idea that students may be dissuaded from studying law by the cost of a law degree, which this year has again increased, or because of other systemic issues, is troubling. Not just this, but we will only achieve a truly diverse profession when barriers to advancement are broken down and people from different backgrounds are properly supported in a collegiate and inclusive environment free from harassment and discrimination. These issues are fundamental to a just and transparent legal system and to the legitimacy of the rule of law. We need diverse representation amongst advocates and judges so that all people who become involved in our justice system can be properly heard and fairly engaged with by a system reflective of our broader community. Despite these challenges, there is real scope for change. There is far greater diversity of background amongst junior lawyers than those who have been around for as long as me. And you only need to look around this courtroom and then look at the paintings on the wall to see that is so. You are in a unique position as new lawyers who are entering the profession at a time when more than ever your words and actions are having an impact for good. You are being heard and taken seriously when you agitate to correct injustices, whether it be speaking out about unsustainable working cultures, sexual harassment or bullying within the profession, unfair laws or systemic failings affecting our society's most vulnerable. I urge you to continue to speak up for those things because they really do matter. You are the future of the profession and will steer the direction that it will take. As a lawyer, you will also need to make difficult ethical decisions at times. With regards to our personal characteristics, lawyers have been the butt of jokes for centuries. Cynics say, of course, there are only a handful of lawyer jokes. The rest are true stories. Jokes aside, you must use the tools you have developed to think critically and not compromise on your fundamental duties to the court and the administration of justice and the other ethical duties you must uphold. Now that you are lawyers, you can get paid to argue instead of just arguing for free. Of course, there is a lot more to it than that. You're an advisor, a problem solver, a mediator, and an advocate for the marginalised. As you go about your day-to-day work, remember that you're not merely dealing with the law in a vacuum as a series of abstract concepts, but law as it applies to people's lives. For this reason, you must strive to deliver legal services competently and fearlessly with courtesy and integrity. Justice Gageler, before he was a High Court judge, once said, "You must be prepared to give the same answer to the same question for the same reasons, no matter who asks the question or for what purpose or in what context the asking may occur. This is foundational for upholding the rule of law." For those of you who will practice law, the way you communicate information to others will have profound consequences for access to justice. For a non-lawyer, law is often incomprehensible. One of your roles as a lawyer will be to make law accessible to others, sometimes by deciphering legal complexities, other times by deciphering poor legal drafting, and sometimes both. One thing you will regrettably strike throughout your career is legislation which seems carefully crafted with the object of ensuring that no one can understand it. Your task is not just to understand it, but to explain it clearly to those whose rights and interests are affected by it. As lawyers, we must not keep the law locked up as something knowable only to us. A client reading your advice should be empowered to understand your meaning, not mystified and confused. So be clear and concise in your writing and your speaking. Plain English is powerful. Consider, do I really need to say aforementioned or herewith? Must I sprinkle in that Latin phrase? Should I really use double negatives, tautologies and wordy clauses to take up a whole page? I would suggest the answer to these questions is obviously no. The best advocates make their points simply and succinctly. Unfortunately, some of the most experienced lawyers and judges could also use that reminder. Do not pick up bad habits from those who have fallen into them. I also want to speak about failure. I would not be surprised if there are quite a few overachievers and perfectionists in the room today. Even so, at various points of your career, you will make mistakes, some minor, some more serious. When you do make mistakes, your commitment to honesty, integrity and the administration of justice means that you must take responsibility, correct what you can and learn from those errors. You must fail at times in order to grow. I myself have made many mistakes over the year, far too many to remember. What is important is that you try not to make the same mistake twice. So even as Chief Justice, my decisions have on occasion been successfully appealed to the High Court. At those points of times, I'm obliged to tell myself that the High Court is never wrong. But in fact, at times, even dissenting High Court judgments have later become the law. Finally, I want to emphasise that your mental health is extremely important. This may sound unexpected at this type of ceremony, but the law is not everything. There may be times when you feel overwhelmed, burnt out or distressed. If you do, you should not be afraid to seek professional help or take a step back when you need to. Also remember that the law is a collegiate profession and in times of difficulty, the support of your peers will prove invaluable. For example, although you might find it hard to believe, I was admitted quite a long time ago. I lost my first case and I lost many more after that. If I was honest with myself, probably more than I won. But throughout my 35 years in practice, I could always count on the other barristers on my floor to share my disappointment at the unfairness of the verdict, the slight tactics of opposing counsel, and most often, I regret to say, the obtuseness of the judge or judges before whom I was appearing. I hasten to add that I do not include either of my fellow judges on the bench in that comment. On behalf of all the judges of the Supreme Court, and particularly those sitting with me today, I once again congratulate you on your admission and welcome you to the legal profession. The Court will now adjourn.
All stand.